I'll call the second case now, in re petition for disciplinary action against Michelle MacDonald, and the record should reflect that Justices Chudich and Thiessen are recused from participation in this case, so they'll be exiting the hearing. And then let's have counsel for the parties identify themselves for the record first, so that we can ensure that their equipment is working. Counsel for the director, could you identify yourself, please?
Good morning. My name is Keshini Rathnayaka.
Good morning, counsel. And counsel for the attorney, could you identify yourself? Senator Champion, are you on with us? You're muted. We can't hear you. Mr. Champion, are you there? I don't know if Marshall, if you can unmute him. Okay. I'm not sure. We're having some technical difficulties with counsel for the respondent attorney. Oh, there. He's coming on now. There. Good morning, counsel. Can you hear me? Mr. Champion, can you hear me?
I can hear you, Your Honor.
There. Excellent. You're here. Thank you so much. All right. So both counsel, we will give you 3 minutes of time uninterrupted at the beginning of your argument. And then at the 3-minute mark, I will interrupt you and see if members of the court have questions. And I'll just remind everybody, if it's not your turn to talk, please mute your microphone. And with that, we'll hear from counsel for the director.
May it please the court. My name is Keshini Rathnayaka, and I'm appearing on behalf of the Director of the Office of Lawyers' Professional Responsibility. The referee's findings of fact and conclusions of law that respondent knowingly made false statements about the integrity of Judge Knutson, denigrated the Minnesota judicial system, failed to comply with requirements for fee sharing, and failed to comply with the court's 2018 probation order are fully supported by the record. The main issue before the court today is the statements that respondent made about Judge Knutson on the radio show. Those statements are recorded, and what respondent said is undisputed. Instead, respondent challenges the referee's conclusion that her statements violated the rules of professional conduct. The appropriate standard of review of the referee's application of the rules to the facts of the case is clear error. This court gives the referee's findings great deference and will uphold them if they have evidentiary support in the record and are not clearly erroneous. First, respondent argues that her statements impugning Judge Knutson's integrity and denigrating the Minnesota judicial system were merely her opinions. The referee did not err in concluding that respondent's statements were not opinions, but rather knowingly false statements about Judge Knutson's integrity. Respondent knew that her statements about Judge Knutson were false because in 2016, in her prior disciplinary proceedings, she was confronted with evidence that her beliefs about the circumstances surrounding the September 2012 order were wrong. In January 2018, this court told respondent that her statements about Judge Knutson violated the rules of professional conduct and suspended her for 60 days, in part for making those statements. Next, respondent argues that her statements were protected under the First Amendment. 3 years ago, this court appropriately rejected this same argument from respondent. Now respondent argues that since she was a candidate for judicial office, she had an expanded First Amendment protection. Respondent offers the court several cases to try and support her position. However, none of these cases provide First Amendment protection to a candidate who makes knowingly false statements about a judicial officer, and that is the critical distinction at issue here. The referee noted that respondent's false statements about Judge Knutson and her denigration of the Minnesota judicial system were egregious and compounded by the fact that they were made 6 months into respondent's probation and following this court's order, finding her statements regarding Judge Knutson in the previous disciplinary case were demonstrably false. The referee's recommendation of supervised probation does not reflect the seriousness of respondent's misconduct and is not supported by this court's precedent for misconduct that includes dishonesty.
Counsel, I just want to stop you and see if members of the court have questions. Justice Anderson?
Yes, I want to ask you about, let me see if I can get it up here. I want to ask you about some of Attorney MacDonald's generalized criticisms. Now, you focused on the specific references to Judge Knutson, and Senator Champion and I will discuss that when he has his turn. But I'm looking at some language here that says court orders are damaging people and families. There is a severe failure to follow the rule of law, to follow our Constitution and uphold it. And quite frankly, our civil rights are being violated by courts all over the state. What is the director's position about that statement and whether it is a violation of any rule and found by the referee to be a violation of any rule?
Right. Those statements, so the director's position is that those statements do violate Rule 8.4D, which is conduct that interferes with the administration of justice. And the referee did make specific findings and conclusions that those statements do violate that rule, and I believe Rule 8.2A as well.
Where do you draw the line between harsh but legitimate, or at least non-violative criticism of courts and criticism that in fact violates the rule? And how do we determine that? I mean, the Judge Knutson comments, it seems to me, are in a different box, but these comments maybe are a little more difficult to deal with given our rules. How did you respond to that?
Well, Justice Anderson, I think the line is that when the statements are false, that is the line. That attorneys and candidates for judicial office are prohibited from making false statements about individual members of the judiciary and about the judiciary in general. So here, respondents just overall statements that judges are violating people's rights every day is an overly broad statement that is not supported by facts. There weren't specific examples that were given. She didn't express that really as an opinion, but rather just a statement of fact that the current status of the judiciary is that the courts are violating people's rights essentially left and right all day long without any specifics. And those kind of comments, when made by an officer of the court who has an obligation and duty in protecting the administration of justice, are harmful. The public perceives comments that are made about attorneys, specifically about the judiciary, in a different light. And so they're—
Well, the thing that I'm struggling with respect to those comments, though, is where and how. I mean, I tend to share your. I mean, I think the comments are very disturbing. But what I'm worried about is how do I draw the line when a lawyer stands up and says courts are not enforcing the legislature's statutes on vehicle forfeitures or asset forfeitures in a drug case, or we have complaints about systematic unfairness and courts aren't. So I mean, all of those cases could raise some of these same issues, it seems to me. And is that what the rule is intended to get at? And how do we draw that line, if at all?
Right. I mean, I think there's a difference between making those comments in relation to a specific case and providing examples and just making blanket statements about the judiciary.
So you would link the statement, because I think she does say this, she cites the Grazzini-Ricci case as an example, and that's where you would go with this in terms of why this is different.
Well, correct, except the problem with her example of the Grazzini-Rucki case is that the statements that she made were not correct about what happened. They were false statements. But yes, I mean, in general.
I think we've adequately explored this, so I don't have any further questions, Chief.
Justice Hudson?
I have no questions, Chief.
Justice McKeag?
Just to be clear, the director is asking for 90 days suspension. Is that correct?
For a minimum of 90 days, correct, with a reinstatement hearing.
And any other provisions?
I mean, we would defer to the court for what the court thinks is appropriate. I know that in the last disciplinary hearing, there was suggestion that perhaps a mental health evaluation would be appropriate. And if the court thinks that's appropriate, the director would support that. But the main focus for the director is wanting to see a reinstatement hearing so that respondent can prove that she understands what led to her being here today.
And but just to be clear, what would the director be looking for as a means of proof in such a hearing? That's, I guess, what I'm trying to get at. Is there other concrete things that would be helpful if the court agreed with you and did the 90 days suspension and then required the hearing? Is there any additional concrete provisions that the court could put in that would be helpful for evaluation during that hearing?
I mean, I think what we'd be focusing on, is of course what's already required with the reinstatement hearing, which is the acknowledgement of wrongdoing and acceptance of responsibility, which is, was not seen in the last hearing. Respondent, denied any wrongdoing and that her conduct violated the rules throughout the entire process. And then 6 months, into her probation, in the director's position, violated the rules again. So our main focus would be on wanting to see that there is an acknowledgement that her conduct violated the rules.
Thank you.
Justice Moore?
No questions, Chief.
All right, counsel, you can proceed. If members of the court have questions, just unmute yourself. Excuse me.
Respondent has now shown this court that a 60-day suspension was not long enough for her to understand the court's previous message to her. A minimum of a 90-day suspension appropriately reflects the seriousness of respondent's misconduct, which involves dishonesty, and the significant factor that respondent is before the court for repeated misconduct. A minimum of a 90-day suspension is also consistent with this court's precedent for similar misconduct, especially when taking into consideration the numerous aggravating factors that were found by the referee, such as respondent's disciplinary history for the same misconduct, respondent's probationary status at the time of the misconduct, her clear failure to recognize the wrongful nature of her misconduct and lack of remorse, and her significant experience in the practice of law. The referee did not err in concluding that there were no mitigating factors. This court rejected respondent's proposed mitigation in 2018, and respondent did not present any new factors for consideration in this matter either. Most importantly, as we discussed, a Rule 18 hearing is needed to protect the public and the profession. Respondent needs to demonstrate that she understands how her statements about Judge Knudsen and the judicial system violated the rules of professional conduct, and convince a panel that she's not going to continue repeating false statements about Judge Knudsen and generally denigrating the Minnesota judicial system. The director respectfully requests that the court suspend respondent for a minimum of 90 days and require that respondent undergo a reinstatement hearing to prove moral change in order to be reinstated to the practice of law.
Counsel, before you leave, can I just direct you to our 2018 opinion? And could you, I think the director's position is that our court found that the statements made about Judge Knudsen prior to the 2018 discipline and then again in the WCCO hearing interview, because they're essentially the same, were false and made with reckless disregard for their falsity. I'm just looking for language in the opinion that the director relies on to support the conclusion that our court, that you contend our court made with respect to the falsity of those statements.
Yes. If I could just have a moment, I can pull up the court's opinion. So, Your Honor, I believe in the previous opinion, what the court found was that respondents' statements regarding the hearing, that the judge had issued the order without due process, are what were found to be made, partly are what were found to be made false statements with reckless disregard for the truth. So I'm just looking here.
Maybe counsel, you can just look for this and then maybe just give me the citation when you come back on rebuttal.
Sure.
Of the language that you're relying on.
Sure.
All right, and before you leave, let me just make sure members of the court don't have any additional. Justice Moore, do you have a question?
I did have a question,
Go ahead.
Chief. Thank you. Counsel, I'd like to direct your attention to Mr. Champion's assertion in his brief that the finding in conclusion, or the finding actually of the referee relating to the order that was being referenced by Ms. MacDonald was clearly erroneous. And I'm looking at the findings of fact, conclusions of law, and recommendations for disposition per finding 10. And there's a reference to Respondents Exhibit 6 is referring, I think, to the September 7th, 2012. That was the emergency telephone conference order. And then there was a subsequent order that I think was agreed to in October that's referred to as Petitioner's Exhibit 6 on finding number 10. And what I see Mr. Champion referencing is he thinks that the referee's finding there on that issue was incorrect, if I understand his argument, and I'm sure he could clarify that if I've got that wrong. Could you respond to that assertion that the referee's finding there was erroneous?
Sure, and I understand that's confusing and I can clear that up. So what happened during the hearing is that the director accidentally offered the wrong order into evidence. So what was intended to be offered into evidence was the September 7, 2012 order. And instead the subsequent October order is the one that was admitted into evidence. And I think that is what Respondents Counsel, Mr. Champion, was referencing, is that exhibit is not the order in question. But you know, in the petition, throughout the hearing, throughout these proceedings, I think everybody is on the same page that the order in question is the September 7, 2012 order, and respondent actually offered that into evidence. And so the correct order is in evidence, and that is the order that respondent was referring to in her interview, in her radio interview. It's the order that we've been referring to. That was just an accident that happened. Does that explain that issue?
I think it does. Thank you. That's helpful. And if I could follow up with another question, the assertion that I think the director is making based on the October 2018 radio interview is that Ms. MacDonald's comment about that particular order as being issued, quote, without any process is one of the denigrations of Judge Knudsen that the commissioner is relying on in this case, or the director is that correct?
Correct.
Now, Mr. Champion characterizes that comment as really meaning that it was her opinion that that order was issued without any due process. If Ms. MacDonald had said that directly without any due process, would that change the director's position on the appropriateness of that comment?
No, it would not. So the issue is not that she left out the due in the process, and respondent testified at length during the hearing and explained that that's what she meant is due process. It does not change the fact that the director believes that was a false statement of fact. And the reason for that is that hearing did not take place without due process. That hearing was conducted over the phone, and both parties were represented by their counsel during the hearing. The mother's attorney is the one who drafted the proposed order that was eventually signed by the court, and there was a guardian ad litem present as well. And so for respondent to state that that order was then issued without due process is, in the director's position, a false statement of fact. Now, where that statement, I think, would have been, or the way that that statement would have been okay, is for respondent to have said, to have provided the context and the facts that actually happened that day. So to have said, well, there was a hearing, it occurred over the phone, the attorneys are represented by their counsel. However, the individual parties were not there and it happened over the phone, so the public wasn't able to attend. And in my opinion, I don't believe that qualifies as due process. That I think that would have been okay because the facts are there so that the listener can really understand what was happening that day. A hearing happened. She disagrees that constituted due process. With the proper facts, the listener can understand. But the way that the statement was made, just a blanket statement of that that order was issued without due process, that is false when you leave out the facts and circumstances that go along with that statement.
And based on the Graham case, our obligation is to review those statements from an objective lens, is that correct? As opposed to a subjective belief on the part of an attorney regarding the truth or falsity of what they're saying?
That is correct. The Graham court held that an objective standard applies.
Thank you, counsel. That's all I have, Chief.
So can I ask a question, Chief? So if Ms. MacDonald had said that that there had been a determination that there was due process, but she disagrees with that, even if she had provided that limited context, would the director then have a different position?
Yes, because Justice McKeague, the way you phrased it is you're giving the facts. The court has determined that was due process. However, she disagrees, and then she can explain why she disagrees. That's fine. That is an opinion.
All right, let me just pause for a minute and make sure nobody else has any questions. All right, I think we're good. Do you have any concluding comments, counsel, or are you ready for Mr. Champion to go?
I'm ready for Mr. Champion, and I will double check so I can answer your question.
Great.
and rebuttal.
Thank you. All right, Senator Champion. Sorry, you're still muted. Whoop. You unmuted for a second and then you just.
Okay, sorry about that, Your Honor. It looks
There.
like I shouldn't have too many things here. So, Your Honor, may it please the court, opposing counsel, and the general public, because I understand that we are live streaming this as well. Your Honor, under the clear error standard of review, we believe that the director failed to provide sufficient evidence to support the referee's findings that the respondent, number one, knowingly made false statements about Honorable Justice Knudsen or denigrated the Minnesota judicial system. In fact, we believe that because of the proper context, that she was a candidate running for office and she stated an opinion, and any speech that is articulated in that context is protected by our First Amendment. And our First Amendment is clear about not putting forth any thing that would abridge one's right to free speech. Secondly, we believe that the referee failed to comply with the requirements of a fee-sharing representation and failed to comply with or violated the court's 2018 probation order, which required compliance with the Minnesota Rules of Professional Conduct. Secondly, under the clear standard of review, we believe that the referee incorrectly concluded that Ms. MacDonald's significant experience in the practice of law, as well as her disciplinary history and probationary status at the time of the alleged conduct, are aggravating factors and failed to consider or find mitigating factors. Thirdly, what is an appropriate discipline? If any, we believe that the referee recommended that Ms. MacDonald be placed on supervised probation for some period of time, and we believe that Ms. MacDonald should not be subject to any discipline because any and all of her comments on that day on WCCO were protected. And we also believe that when you look under Graham, even if you concede and look under Graham, we believe that the referee did not ask the proper questions, because the proper question is, what would a reasonable attorney do who is running for political office? This question requires a different analysis from our vantage point to be considered than simply an objective viewpoint from an attorney functioning in their everyday practice of the law. Even if you look at Graham, it clearly states, and the director fails to complete the holding in Graham, because in Graham it says, thus we hold that the standard must be an objective one, dependent on what the reasonable attorney would do, consider in light of all of one's professional functions, what would they do in the same or similar circumstances? We believe that the department fails to consider the complete picture and therefore fails in many different ways. Not to mention the standard of review, as we know that because Ms. MacDonald ordered a transcript, the referee's findings of fact, conclusion of law are not binding upon this court. And nonetheless, the court gives great deference and will uphold them if evidentiary support in the record are not clearly erroneous. And we believe—
Counsel, I'm just going to stop you for a minute there and see if members of the court have questions. Justice Anderson?
Thank you, Chief Justice. Senator Champion, I want to direct your attention to a fairly narrow question. There were two statements that Attorney MacDonald made that are of concern to me. One was that the judge did that in September of 2012 without any hearing, without any process, and you're familiar with that. And then the second statement was the crime was with the court when Judge Knudsen did an order that neither party could contact their kids. Now, I look at those two very specific statements, and then I look in the record, and I do see the discussion about, well, I was really referring to due process. But even if you accept that argument, the statement is clearly wrong as a matter of fact, because a hearing was held. And then we have effectively Judge Knudsen accused of committing a crime. That crime was when Judge Knudsen did this order. Now, I look at those two statements. Those are objective statements. And it strikes me as I'm reading the transcript that I don't find anywhere any acknowledgement by Attorney MacDonald that those statements were wrong. She shouldn't have made them, that in the expression of remorse. Am I wrong in saying that she doesn't concede any error here at all, except with that question about process and due process, and that may be something we have to talk about as well.
Thank you, Justice, for the question. I think that we have to put the question in context, and in context of both law and then fact. One is, it is well stated in Bridges versus California. It says it's a prized American privilege to speak one's mind, although not always with perfect good taste or on all public institutions. And this opportunity is to be afforded for vigorous advocacy, no less than abstract discussion. From Ms. MacDonald's perspective, is that it is feasible for one to have heard from the court and for the court to express an opinion and for one to disagree. And we think that it's okay and should be okay in protected speech that when you are running for office, that you are not just operating in court and you're not just operating in that limited capacity for you to be able to speak your mind and to say what you think. That is our privilege. And then if you go to the application even though another court order, it says disciplinary actions, these are not designed to prevent an attorney from, in good faith, espousing a legal cause, however unpopular or seemingly untenable. Disciplinary actions require a different legal approach. And so from what you are saying, she expounded an opinion, and that opinion is protected by the First Amendment. And we believe that this court should also think about how do you deal with these sort of situations when you have an attorney who's running for office and who is sitting for an interview, and you don't always, as a part of an interview, be able to answer and to extraordinarily extract everything that you want to say during a 3-minute or 2-minute interview on WCCO radio. In fact, if you read the transcript, which I'm sure this court has, you'll see that Miss MacDonald wasn't the one who brought up this particular case. That in fact, it was the interviewer. The interviewer asked the question and threw that case into the public domain and into the conversation, and she began to talk about it. And she even started off the paragraph by saying, well, let's see, that one of those loaded questions. Because when you're sitting as a candidate, you're in a totally different space than what we believe that the department is trying to say, that she, again, created the same problem that she was on probation for. No, what she was cited for in your 2018 order was conduct in the court and statements that she made in court.
Chief, that answers my question. I don't have any other questions.
Justice Hudson,
No questions, Chief.
Justice McKeag.
So counsel, what do we do with the fact that Miss MacDonald was actually on probation for this? I mean, some of this directly relating, and she just doesn't seem to be taking any due care with what she is saying about Judge Knutson. And it's not the part about being unpopular. I certainly agree with you that we're allowed to say unpopular things, but here she is repeating things that are simply untrue. And isn't she accountable for that?
Thank you, Justice, for those comments. I think that one, that she will be accountable is accountable to voters, because when you're in that context of being a candidate, you're in a different space. And in fact, if you continue to read the transcripts from the report, in fact, the interviewer began to press her on many different issues, as well as voicemails that she left, and talked about judicial temperament, and talked about, is that what we want as the public? And in that context, they did push. Secondly, I do think that there needs to be a different analysis given in those situations, and we must bifurcate one's work as a lawyer and what we're doing in court, and then when we decide to run for office. And I will quote this. Further in Graham, the court said that constitutional First Amendment rights have long protected Minnesota attorneys from disciplinary action when those rights were exercised either to criticize rulings of the court once litigation was complete, or to criticize judicial conduct or even integrity. Now, I recognize, Justice, that you're saying, okay, if they're unfair, if they're untrue and false, isn't that a conclusion that says now this particular person should be disciplined? I think it reeks of an unfortunate notion if we say just simply because someone else says that it's false and it's untrue, that we may still have a difference of opinion as to whether it's still false or true. And where do we create the space for that to happen? I mean, I hate to say this, but it is true. We don't always agree with everything a judge says, or even a jury. And we criticize them over and over again. So are we saying, based on what I heard the director's position is, no matter what a person says, if it is perceived to denigrate our profession, then one is challenged by our rules. And here's where the problem is with that sort of thinking, is that our profession is a wonderful one, and it can withstand criticism, and especially in the appropriate context. And we should embrace that, because that criticism leads to transformation that is beneficial for us as a system. And I think by taking the director's position really is like saying we should forfeit our ability and our uniqueness to criticize or disagree with the judiciary because we are lawyers. In fact, we know as lawyers, we are some of the most opinionated people around, and we should embrace that. Now, is the issue false? Well, then we should look at whether it's false or someone's opinion. And if it's someone's opinion, then it is protected by our First Amendment rights. And where will that person be held responsible? At the polls. Because as that interviewer who brought this up, who criticized her for temperament and other things, she did not become a sitting associate justice of the Minnesota Supreme Court, no matter how distasteful that we think it is. And the reason why there needs to be a difference, because the court recognized that when you think in terms of defamation, that is harm to an individual. But what we look at in the notion of disciplinary actions is harm to the profession. And there's no evidence to suggest that the profession has been harmed. And in fact, I believe our profession has gotten stronger because of our ability to allow people to speak their mind, but also for us to be able to press them as to whether something was right or wrong. And if you look at that interview, Blois Olson pressed her on whether she knew about where the kids were, when did she find out about it? And those things are things that I believe that our judiciary has the strength to withstand.
One more question, counsel, in regards to mitigating factors, I know it's your position that the referee didn't take those into account. Can you tell me specifically what mitigating factors you are looking for the court to essentially give credit for to Ms. MacDonald?
Yes, thank you for that. And we recognize that the court has discretion when it comes to what should or should not be, or how this court will weigh any discipline here. So one, we think that mitigating factors is her significant inexperience being a candidate. You know, as we sometimes say, well, you've been in the judiciary for 30 years, but in this context, she's a candidate. And sometimes candidates don't know everything that they need to know, nor are they always prepared for interviews. So I think that there should be some that is a mitigating factor of her experience. Secondly, I think that betterment of the profession as a mitigating factor, that she's done work in order to better our profession. And we should embrace that. We should look at how is it that her work has better our profession. And I think that's something that we should do. I think that significant experience as a lawyer should not be an aggravating factor in this context, because in this context, we're talking about her as a candidate and her exercising her First Amendment right. And we believe that her prior discipline, the director misstates it, because the director says because she was disciplined before for her behavior in the courtroom and some things when she was taking pictures in the courtroom, that's the same as when you're on or conducting an interview, and in that interview you are criticizing an opinion. Well, I just read you case law that says once a case is done and is complete, that you can criticize it, and you should be able to do that. So prior discipline in this context should not be seen as an aggravating factor, but a mitigating factor. And then last but certainly not least, it's my understanding she was not on probation for being a candidate. So this is a technical notion of being on probation that should not be an aggravating factor. So I think, again, specifically, Justice, because you asked such great questions, her significant inexperience being a candidate should be a mitigating factor. How she's bettered the profession, and that she really wasn't on probation, and some of the other things that I've already talked about. I think you're on mute.
I am. Thank you very much for catching me.
I'm not always like that.
Justice McKeag, you're finished with your questions?
I am. Thank you, Chief.
Okay. Justice Moore, do you have any questions?
I do. Thank you, Chief. Senator Champion, I understand that you are advocating that this court really abandon the Graham test here and adopt a different test on this issue. I think from the Ninth Circuit, from this Yagman case. Is that what you're asking us to look at here?
Well, I'm asking you to do two things. One is to consider the Sullivan notion of actual malice, and I understand that in Graham that there's that objective standard. But I think what I'm also asking is for this court to clearly articulate what are the things that one should look at when we think in terms of an objective standard, and what sort of objective standard when someone is running for office. Because when you look at what was written in the holding in Graham, because I think the board misses this, because the board only cites this portion. We hold that the standard must be an objective one. That's it. But there's more to the holding. It says must be an objective one, dependent on what the reasonable attorney consider in light of all professional functions would do in the same or similar circumstances. That's important.
Well, let me ask you, Senator Champion, about a follow-up question based on the tests that I think you're asking us to consider. And you make this statement. You say that the bulk of Ms. MacDonald's comments concerning Judge Knudsen were based upon, and I'm quoting here, fact-supported opinions about his unfairness, end of quote. So circling back to Justice Anderson's question, the statement that Ms. MacDonald made during the interview that the September 7th order was issued without any process, without a hearing. How is that statement factually accurate? Isn't it true that Ms. MacDonald's client had an attorney that was part of this telephone conversation and actually was asked to draft the order that your client's criticizing Judge Knudsen for issuing?
Thank you, Justice, for that question. That is a very good question, as usual. Here is our position. Our position is that we have an individual who's a layperson who is also the client of Ms. MacDonald, who was not a part of that telephone call. So the notion of being included in process and transparency from that person's perspective, she was not given a due process.
But Ms. Counsel, if I could push back on you a little bit there,
please.
She was represented by an attorney. I mean, that's the nature of our system here. If someone's represented by an attorney on a matter like that, the client isn't going to be part of that discussion. It's going to be between counsel and, the judge is going to hear both sides and make a decision. And that appears to me to be what happened here. This notion that Judge Knudsen just did something kind of ex parte on his own without any input from Ms. MacDonald's former client here just seems to be, as others have said, demonstrably false.
Well, thank you, Justice, again for that question. I will still go back to this particular notion, Justice Moore, is that yes, when you look at the facts of what occurred, you had an attorney representing the client on the telephone. Where the disconnect happens is that this telephone call had such wide-ranging and such a major impact on the underlying case that a person who is not a part of the process, even if you have your attorney there, you feel like you're left out of the process. And a part of due process is notice and understanding and one's ability to see what's going forward. You and I may not have used the word without process. And in fact, my client was really trying to say without due process. And we may even disagree with that. We may say, no, we think a telephone call was appropriate. We also believe that because the client's attorney helped draft the underlying documents, that was process itself. But I'm going back to the notion around one's opinion. A person has an opinion. And
Counsel, I just want to stop you though. I mean, it just feels to me like we're running afoul of, I think it was Senator Moynihan who said everybody's entitled to their own opinion, but they're not entitled to their own facts. And the fact is there was a process going on before this court order. And the fact is Judge Knudsen did not commit a crime. So, I mean, I just don't see it here. I
Well,
just don't see it. I don't see an opinion. And the fact that you're a candidate for office does not make everything you say an opinion. Help
so,
me.
Chief Justice Gilday, you know, your eloquence always goes before this particular body, and your questions are always piercing and straight to the point. But what I will say, Chief Justice, is that I agree that you are entitled to your opinion, but not your own facts. But we've been living in times when people seem to have alternative facts, whether we agree with them or disagree with them. But there still has to be a space for that as well, even if we disagree with them. And that speaks more to what we're trying to do here, which is what we're advocating for, is that the referee should have gone through a different sort of analysis in order to understand exactly what was going on and the context and weigh those two things. Chief Justice, I think it's important for that to be weighed, and there needs to be a process for that. But what the board has articulated on every question that was put before this body is that they would say, if you criticize the judiciary and not use names, you're still a foul of the rule. If you criticize the judiciary and you could state your opinion, you still will be a foul of the rule. And even when questioned by one of the justices that I can't remember right now, when asked, but if it was framed this particular way, saying, in my opinion, and articulating everything that the court did and every conclusion the court reached, and then say, but in my opinion, this, then perhaps she might not be a foul of the rule. The problem with that analysis is this: then you're not giving great credence and respect for the campaign trail, and when you're out and when you only have 2 minutes and when you don't even know what the interviewer is going to ask you, and you are flying by the seat of your pants in order to articulate something in real time. Because remember, my client didn't bring this up. The interviewer brought this up. Blois Olson brought this up, and she could have said, no, I don't want to answer that, and then that could affect her politically, or she could give her opinion and that's going to affect her professionally and potentially politically. But I'm just saying that there has to be a clear directive here as to the paces that a referee should have to go through in order to determine whether someone in a political context said something or did something, and whether their position or opinions is protected by the First Amendment. Our constitutional rights are important, and just simply because we become lawyers, we do not forfeit our right to to our constitutional rights. And do I think it's right? No. Would I have said it? Possibly not, right? But I know other people who would, and other people who have. And you all, as a court, have recognized this important tension between disciplinary actions and one's First Amendment right.
But counsel, those other people who might have said that, I'm sorry, I didn't mean to interrupt you, but
it's okay.
But those other people were not on probation.
Yeah,
for the circumstances. I mean, it's the same. She's not in the same boat as everybody else.
But Justice, would you not give a deference to the fact that it is a different set of conduct? She's not in a courtroom where she is taking pictures in a courtroom. She's not interrupting allegedly a judge and being held in contempt of court. She's not, any of the facts based on your 2018 order are not present here. It is her opinion as to what occurred. That is what makes this different. That is what makes it necessary for this court to bifurcate exactly what the conduct should be, and how do we protect one's First Amendment right while allowing them to state their opinion, but also make sure that they're being true to our profession as lawyers. And I think that is the difference. And you have seen that, because it is an order, but it is not that conduct that we are pushing back on. We are now pushing back on something she said in a candidate or a process of wanting to be elected to office. That's the difference.
Thank you, counsel. Your time has expired. Let's see. We'll hear from counsel for the director on rebuttal. Go ahead, counsel.
Thank you. So I did look at the opinion and found a few passages to highlight for the court. So on page 241 of the opinion, the court is discussing the referee's findings, which were all adopted by the court. And there, the court highlights a specific statement where respondent said, and you are telling me that you can't be, I'm sorry, and you are telling me that you can be impartial in this trial, which you haven't done since day one. And the court found that that statement, unfairly attacked Judge Knutsen's integrity in violation of Rule 8.2a and 8.4d. So of course, while that's not literally the same statement, it's an example that the court highlighted in the last case of respondent attacking the integrity of the judge in a false manner. Then on page 242 to 243 of the opinion, the court is discussing the referee's findings that the allegations in respondent's federal lawsuit violated rules 8.2 and 8.4. And the court specifically discusses the allegations that were made in the lawsuit, which are that Judge Knutsen retaliated against Ms. Grazzini-Rucki and respondent, compromised the Minnesota court information system, usurped case files with the assistance of opposing counsel, signed documents that he knew were false, and acted without jurisdiction or legal authorization. And the referee found that those statements violated rules 8.42, 8.2a and 8.4d, and the court then adopted those findings as well. So that last part there, that he signed documents he knew were false and acted without jurisdiction or legal authorization, I think those are very comparable to what was stated in the current case, that he issued an order without due process. So I would direct the court to those passages in the previous opinion where the court has disciplined respondent for making very similar statements. While not, exactly on point, I think they're analogous there. And then one final passage to highlight from the court's previous opinion begins on page 247, where the court stated that no reasonable attorney in MacDonald's shoes would have made such serious allegations about a judge's integrity and impartiality without substantiating evidence. And then again, here in the present matter, we've got this serious allegation about Judge Knutsen's integrity that was made without evidence. When she said that the order was issued without due process, that's not correct, and that was a false statement. And the court also specifically stated, our conclusion applies equally to her allegations in the federal lawsuit, in her complaints to the board on judicial standards, and in her correspondence to other attorneys and public officials. As we have held, when an attorney abuses her First Amendment rights, she is subject to discipline. So those are the three passages that I would highlight for the court from the 2018 opinion that I think relate to the current misconduct. And then in conclusion, I just want to highlight a few things from respondent's argument. Respondent stated many times he characterized respondent's statements as criticism. And I want to highlight the director's position, which is that respondent was not criticizing Judge Knutsen's decisions or his procedures in the matter. She was making false statements about what happened, about the procedure, the process that came before the issuance of that order. Not criticism.
Counsel, if I may stop you just a moment, just backing up a little bit in terms of your responses to the chief's question. I think, and maybe I misheard the chief, but I think part of her question was, did we ever say in the opinion that the statements were false and made with reckless disregard? And I don't see any place in the opinion where we said that. And maybe if that wasn't the chief's question, I'm asking it now. It seems to me what we did is we adopted the referee's conclusion with respect in that regard. But is that what you're saying though? Or is that encompassed in what you're saying?
Yes, I mean, I guess my understanding was that by adopting the referee's findings, that those statements were false and made with reckless disregard for the truth, that is what the court was stating.
Counsel, could I ask you to respond to Senator Champion's suggestion that we should abandon or at least modify the Graham test? And if I heard him, he seems to be suggesting that we live in some type of a post-truth era here where we should give space to so-called alternative facts or different versions of reality. What is the director's response to that assertion?
I do not believe we should adopt the test that was set forth and the factors in Graham. And I also do not believe that there is space for alternate facts. There's certainly space for alternate opinions and views, but not for facts that are undisputed. And I think that's a critical distinction here between our two positions, is that the director's position is based on the facts that happened preceding that order. And respondent's position is that that was simply, an opinion. But no, I don't believe there's space for individuals to create their own facts, but only to give their opinions.
Counsel, related to that, Senator Champion suggests to us that we should be making a distinction between attorneys who are acting in the course of their typical practice in a courtroom and attorneys who are candidates for office. What is your response to that?
I do not believe there should be a distinction. And I would note that in the previous disciplinary hearing, not all of respondent's misconduct happened in the courtroom. Some of it certainly did, but respondent was also disciplined for the letters that she wrote to the Board on Judicial Standards, to other attorneys, and to members of the public. Those letters were not written in the courtroom. And so no, and I mean, the critical piece here is that these were false statements. And so the rules should not be altered to allow an attorney to make false statements about a judge, about the judiciary, or really about, I think, anything when the statements are knowingly false, because as an officer of the court, we have an obligation to not make false statements of fact about things that have happened.
Thank you, counsel. Your time has expired. Thanks to both counsel for the help you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. Counsel, you are free to exit the Zoom hearing with the thanks of the court, and we are adjourned.